10488 Owens v. Owens. Whenever you're ready.
Good morning.
Good morning. Would you like to reserve time?
Yes, I would. 3 minutes for rebuttal, please.
All right.
Thank you.
You can start whenever you're ready.
All right. To refresh this court, these parties were married on July 12th of 2012. They had 2 minor children, LO and RO. The demise of their marriage began when wife discovered husband was cheating on her in September of 2019. A lot of chaos ensued after that. There were arguments, there were mental health issues, there was screaming, yelling, fighting, there was marijuana use, there was oxycodone use.
Wasn't that prescribed?
I'm sorry?
That was prescribed, though, correct?
The oxycodone, yes, was prescribed.
And she had a legitimate medical marijuana card as well, right? So it's
I'm having a difficult time remembering if at that time she did, but at one point, yes. Yes, she did have the medical marijuana card at some point. Yes, and there were inpatient rehab and then therapy eventually, and the therapy continued throughout, and it's, I believe, still continues today for these parties. During the pendency of litigation in May of 2020, there was an allegation of child sexual abuse, which changed essentially the trajectory of this entire case. There were 4 assignments of error. The first assignment of error was that the trial court abused its discretion in the valuation and division of marital property. The trial court used an incorrect and inconsistent valuation date, division date for valuing the marital residence. The court determined that January 16th of 2020 was to be the valuation date. Husband provided an appraisal of the marital residence from May of 2020, which actually ended up quite a good thing in this case because wife stopped contributing to the household expenses in April of 2020. So the appraisal actually lined up very closely with when that occurred. Instead,
So one is before the date, the last date, or the date of separation, and one is after, right? Of the appraisals.
yes, so they separated in January of 2020. Mm-hmm. The wife stopped contributing to the marital expenses in the home in April of 2020. Husband's appraisal occurred in May of 2020. But the court chose to accept wife's appraiser, who provided an appraisal from July of 2021.
Okay. So the last day of the marriage is in between the two, but the date of the separation is before the both of them.
That's correct.
Okay. Now, I think there was some evidence with regard to the July one that there had been a boom in the housing market. To what specificity was that evidence? Was there a date or any time period that that boom was assessed for?
Both appraisers essentially concurred. They agreed that there was a boom, but they didn't nail down a particular date. Or dates, really, of when that occurred. I mean, I think that they indicated that the boom sort of started around the time that husband got his appraisal. But, you know, it's the time frame is, I would say, I mean, I don't remember if either of them really specified, but I would say that their testimony was that it began at the time that around the time that husband got his appraisal done.
Okay.
In this area.
So why did the court choose the July 2021 appraisal over the May 2020 appraisal?
So I'm unclear about that. So the case law that I've read indicates that the court should provide a reason for that. And in this particular case, I didn't see a reason. The reason stated essentially was that there was a boom in the real estate market, but from my perspective, that didn't really make sense because wife had already gotten herself a place to live in 2020, and both parties had essentially moved on from that perspective. They had already divided, separated, let's say, their financial affairs at that point.
Okay.
So I'm not sure. And I would be asking the court, the same question, essentially.
Well, ultimately, it seems as if that July date that was relied on was after the last date of marriage and after the date of separation. Would you agree with that?
The July of 2021 date, absolutely. It was more than a year after the date that the parties separated, essentially.
Do you want to turn to the stock?
Yes, so husbands should be given, credit for well, let me address one more thing about the house. Besides the equity after the parties separated, there was also premarital equity. So husband purchased this house in December of 2009, and he actually refinanced the house in October of 2010. So what I was asking the court for was to give him some premarital equity because there were financials provided with those settlement statements. And even if the court did that, the wife would still be receiving more than half of the marital. You would still be including 2 years essentially in equity that occurred prior to the parties' marriage.
So what would be the equation that you would ask us to use?
Yeah,
Or
so
that you thought that the court should use, I should say.
yeah, so I think there's a couple of different options as far as that goes, but I think that, and there's also, husband came to closing with some funds each time, but I think that determining essentially the value at the time that they purchased the house and that he purchased the house in 2009, and then the value that the house that the court that the title company or the appraiser essentially determined was the value in 2010. And so I would deduct the 2009 number from the 2010 number, and that would essentially be, it's as close as we can get. It's not going to be perfect.
Counsel,
Yes.
I thought that the money for the down payment came from a joint account.
So I'm sort of laughing because essentially the money that he came to closing with it didn't end up being really a down payment on the house. Okay, so it ended up going towards closing costs and things like that. So it actually didn't even go towards the equity of the house. But he borrowed funds from his mother initially for that. He did that in 2019, and I think he also did that in 2009, and then I think he also did some of that, although to a lesser extent, in 2010. There were some funds in a joint account. I think what you're referring to is there were some repairs and things done on the house, which wife claims came from a joint account. I think the issue with that is really tracing what part of that was each of the parties, and I think wife's counsel was relying on a check that was deposited from a car accident that she was in that was a substantial amount of money. I think it was $10,000 or $14,000. But the issue that I have with that is that check wasn't actually deposited into that joint bank account until after the second closing in 2010 on this house. So,
But wasn't there evidence that the loans from husband's mother, that wife had paid those, had contributed towards the payment of those?
no, actually, neither of the parties really paid her back for those loans.
Okay, so those loans are part of the ones that are still outstanding that was
Yes.
relied upon for the decision on the attorney's fees.
Well, yes, that's exactly right.
Okay.
That's exactly right.
All right.
The court determined that there was not enough evidence to trace husband's premarital equity in the Equinity stock. I'm not sure exactly what additional evidence the court was looking for, but as I pointed out in my brief, wife's counsel outlined in her appellee brief exactly what husband's evidence showed regarding the stock, and it was that he had 293.502 shares of Equinity stock prior to marriage. He ended up spending 100 shares after the folks got married to pay for their wedding. And then he did continue to contribute to that. So he's not concerned about what he contributed to during the marriage. He accepts that that's marital and that gets divided, but he's just asking for credit for what he had prior to marriage. The second assignment of error was that the court abused its discretion in granting custody of the minor children to mother and granting father such minimal and restricted parenting time. My brief went through all of the 3109 factors. I'm not going to review that here, but I did want to point out a couple of thoughts that I had about what the court ultimately decided about the custody and the parenting time arrangement. As I was thinking about this case, going through it, I think ultimately the parenting time and the custody decision doesn't really make sense to me. I think that if the court believed that father perpetrated the sexual abuse, I don't think he would have been given any unsupervised time with these children.
I think that's what makes this case sort of tricky, because it
Yes.
was unsubstantiated, right?
Yes.
So there's this language about, well, we're not here to determine whether it occurred or whether it didn't occur. We're here to put together the best situation for the child so that she would feel safe because she feels that it occurred. So
Correct.
would you say that that determination is an abuse of discretion? In other words, using that as the basis for determining custody and shared parenting, do you object to that?
I object that the parameters that were put in place do not increase the safety or wellness of the minor children. I mean, for instance, father must have another adult around to help the children with going to the restroom during his time, but the nap time must occur at his mother's home. If there's another adult that's around during his parenting time that can help with the bathroom time, why isn't that other adult supervising the nap time? Also, I mean, why do we have to upend his entire parenting time, which, by the way, only one of these children had nap time at this time. So he has to manage the second child to take the other child to his mother's to have a nap time in the middle of his already very limited parenting time. So I think that's the biggest thing. And the court ordered...
Is your issue, though, that there has to be, I thought your issue was that there shouldn't have to be supervision at all.
Well, the court essentially removed supervision.
But there basically is.
Well,
There has to be
yes.
somebody with him when the child goes to the bathroom and when the child naps. I
Right.
mean, I don't know when he's really going to be able to be alone with these kids.
Yeah. So I think ultimately the issue comes down to, and I kind of talk about this a little bit later. I mean, Dr. Basman may have seemed clear in the transcripts about what he was intending with the safety plan that he wanted put in place, but the guardian ad litem didn't understand what the safety plan was. My client didn't understand what the safety plan was, and it wasn't until I was cross-examining him on the witness stand that I really understood what he meant by a safety plan. And what he meant by
Is it that the JEIL didn't understand what it was, or didn't understand how it fit into the context of parenting time?
No, my understanding from the JAL
Well,
is
there's some nuances here,
yes,
obviously.
legitimately, we did not understand what that meant. Through cross-examination, we were able to understand that it meant that he needs to go to therapy, work with a therapist to help essentially accept that the child believes that this happened and create ways for, discussing if she wants to discuss, or just manage the fact that, you might believe that this didn't happen, but she does believe. And so how do we manage that? So it wasn't really until cross-examination occurred that became very clear. And ultimately, my client had been in therapy, had been doing this. He had been addressing the issues, that had come up throughout this case, throughout the year and a half of this case. And my client...
I'm going to pause you, and I don't mean to interrupt your chain of thought. I mean, obviously, you're not going to get through your assignment of errors with the allotted time.
Yes.
So I want to check are you okay if I give each side 5 additional minutes?
Yeah, sure.
Okay.
So
that means from where you are now, you actually have about 4 additional minutes.
Oh, okay.
Okay?
Thank you. So I think that the court seemed to have a real issue with the discussion that father had with the child in front of the community supervisor about lying. And I think that what I would like for you all to understand about that conversation between the father and the daughter was that the child was essentially telling father that she knew that she'd made untrue allegations. Father obviously already knew this, but father didn't have the help of the child's therapist to help him know how to handle these situations as they came up. And he was dealing with these things after the fact with his own therapist. So he thought by discouraging the child about lying that he was encouraging the child to tell the truth. And now I think he understands the nuance of that after working with therapists, but didn't understand that at the time. The third assignment of error regarding child support is pretty straightforward. Father should be given credit for his contribution to daycare during the time mother was not working. Mother was not working from June of 2020 until May 6th of 2021. And if the court wishes to order father to pay support from June 1st of 2020 to May of 2021, the court would need to run 2 child support computation worksheets. One which reflected their incomes during that time period, and then a second one starting in May going forward that reflected their current incomes.
But you're not on this appeal. I think there was some issue of whether you were disputing the income assigned to the parties. And I think in your reply brief, you said, no, it's not, the income that was attributed to the parties is fine. It's the retroactivity of the order that you're appealing.
Essentially, certainly from May going forward, no, I'm not arguing with that. I think that retroactively, the court did not take into consideration the fact that mother was not working during that time. She essentially assigned, she ran the child support computation worksheet, yes, currently, and then backdated it. And both of the parties had changed jobs throughout that time period. And as recently as both parties changed around the same time, oddly enough, around May or June of 2021.
Yeah. But to Judge Krause's point, was this argument made in the briefs?
Yes. Are you asking me if it was made?
Yeah,
yes.
yeah, because
yes,
you're
it was.
saying it should be split based on, and you're making an argument that has to do both with the backdating and with the calculation of the amount.
Yes, and I think my biggest issue with the calculation is that, the father was contributing to this daycare, which wasn't really necessary for that entire year because mother wasn't working. But the children were still going to daycare.
Mother's argument was that daycare was necessary because she was looking for a job, and it's very difficult to look for a job when you're taking care of 2 small children.
Yeah, so there was no evidence provided to me that mother was looking for a job. Just wasn't. She didn't provide any evidence regarding where she looked, any emails, resumes she sent out.
But she testified to such,
She
right?
did, and
Isn't the trial court, isn't that in the purview to determine the credibility?
yes, I think that, again, my client would just like to be given some credit for his contribution to that, essentially, to the daycare. And then the fourth assignment of error is regarding attorney's fees, and the marital assets were divided, in my opinion, more in wife's favor, and wife has always had a higher income than husband, and there was no award of temporary spousal support. And that leaves conduct of the parties for why she may have granted the attorney's fees. The court pointed to no conduct on the part of husband that justified the attorney's fees and seemed to consider the fact that husband's mother lent him money to be relevant, but did not consider the fact that mother also testified on several occasions that her father had also lent her money for this litigation.
Well, I mean, it seemed as if the court was saying, hey, because mother lends and without the need for repayment, I think was the language of the trial court. I found that interesting.
Yeah, so I'm not sure. I just, under the grounds that the court has stated that the attorney's fees are appropriate, I didn't see that those were justified, essentially.
All right. Thank you.
Thank you.
And I still have your 3 minutes reserved. All right, so, good morning. So you have
There's a
whole,
certain issue
you have a
like-
whole 20.
If there's a certain issue you'd like me to address, I will, but I want to mostly reply.
I mean,
reply brief.
if it doesn't drive you nuts.
No.
Why don't we go backwards?
I've been doing this a
I
while.
mean, why don't we start where we ended? Why don't we start where we ended? We don't have to go backwards. Why don't we start with the attorney's fees, since that was the last thing that we talked about?
That's, I'm
And then from
happy
there,
to
go
do
wherever
that.
you want.
I'm happy to do that. So, on attorney fees,
Because it seems as if the trial court was relying on the non-payment of monies as the basis for awarding the $15,000 attorney's fees.
right, so there were several reasons. One is father had gotten a lot of money from his parents, at least 40 that we saw in the trial. They had $1 million account that he brought into the trial. He did not testify he had to pay it back. In fact, his mother said, well, I'd like to get my money back someday if the house sells. But the judge gave him credit for that $10,000 loan off the top of the equity in the house. Then there was the $30,000 loan for the food truck, which actually took his income to half of what it used to be when he decided to drive the food truck. He actually made as much or a little more than she did in the beginning of their relationship. But the judge also looked at the fact that she had to borrow the money for attorney fees, for the experts, of the mental health people that we had to get involved, like Dr. Bassman, and all these things that she had to pay out of pocket for. And she wasn't working from April of January of 2020 through May of 2021. Now, she got a little bit of employment. She got some FMLA. She was on Federal Family Medical Leave Act, and she was not in rehab. She did go to the Beckett Center for some mental health help. She was never in rehab for any drugs. In fact, because of the claims, the judge tested her the first day of trial, and she was clean. So the other reason was that this case became crazy, incredibly expensive because of the allegation against Dad. All of a sudden, we had all these mental health professionals. We had to subpoena Children's Hospital. We had to bring in Children's Hospital.
How would that be relevant in then awarding attorney's fees to the wife when that's something that is possibly out of the control of the husband because it did come out as unsubstantiated?
I don't disagree with you on that, but he took no responsibility for it at all. And when you look at the trial transcript, you'll see that when I asked him, what is your plan, your personal plan for safety for your child, he couldn't answer the question.
Yeah, but that didn't have to do, I mean, that's after the experts were already retained. I mean, there was the allegation and all these experts. I mean, that was you just argued that the expenses went up because of all these experts. The fact that father later on is not taking responsibility doesn't have to do with.
If he'd taken responsibility from the beginning, maybe we wouldn't have to have all this.
Well, he said he didn't do it.
When you say responsibility, you're
I
talking
don't disagree
about.
with you, and I was a criminal defense attorney for a long time.
No, you were.
But this is a
But when you
different
say
arena.
responsibility, that's sort of, you're talking about just,
For what the child was feeling.
okay.
Dr. Bassman was very
But that's
clear.
different. I mean, I don't know if that's the word responsibility.
Okay, they didn't take any ownership of what his daughter's feelings were and how to deal with them. He's the father. He should take some ownership of what his own child is feeling and how to deal with those issues.
But then the
with them.
trial court basically, in essence, articulate the rationale for the award of attorney's fees. And some of the things that you're arguing, I'm not sure is in there.
Okay, well, I have it right here.
Okay?
Many of the issues in this case were complicated by the allegations of abuse and the need for so many professionals involved, just what I said. Father has had a history of being helped financially from his mother without the need for repayment. Equity requires the court to weigh the various financial situations of the parties. He got a lot of non-marital assets, retirement and things that were his, and compensate for the unequal ability to afford the litigation. And that's the situation that mother was in. She made about $38,000 from FMLA, unemployment, and her one little bit of pay that she had in 2020. He made about the same. He made about 32.
So he's relying on the unequal ability for the parties to afford the litigation. But it seems to me that what he is relying on with regard to Dad is speculative, because he's speculating that there will be no need for these loans to be paid.
Dad never testified he had to pay them back. There was no evidence he had to pay them back.
Mother testified that she expected to pay. Grandmother
No,
said. I don't know.
grandmother said, I'd like to get my money if the house sells.
Okay.
And she got her $10,000, which was the house money, credited in how the judge determined the equity.
Okay. I get where you're coming from.
Okay.
All right.
The equity argument is the thing I really want to address. I think there's great confusion about what equity is by the appellant. So the house, first of all, premarital equity. If you look at Exhibit B, it's very clear the parties equally contributed. Now, he wanted to parse in the reply brief, oh, well, wait a minute, some of that money might have gone for food or whatever. Well, look carefully at the exhibit, because you'll see that all their paychecks went in there. And just as an example, on page B1, she contributed $1,751 of pay into the account. At the same time, he contributed $1,000 into the account that month. This is back in 2010. He said, well, she used the debit card all the time, and I used a credit card. Well, guess how much was on the debit card? $770. And how much was on his credit card? He paid, find it here. I know it's here. I think it was $2,000, roughly $2,000 every time he paid the Chase card. So who paid more money out of the account? So clearly, they were pooling everything. They paid everything from the account. They auto-paid the mortgage from the account every month. She contributed equally to that. So that's a misnomer.
Because they were together, living together when they bought the house. This is not a situation where he owned the house, they get married, and then she moves into a house that he owned.
No,
This
they
was-
actually bought it while they were together.
They were together, right.
And they put it in his name. His mother gave him 10 grand, not for down payment. There was no down payment. She's right. There was never a
It was
down
settlement
payment.
costs.
It was settlement costs.
Right.
And it was, and as I recall, wasn't it purchased upon agreement of both parties to purchase the home?
Oh, yes. In fact, she had to sign a letter that's in the exhibits saying, I agree to him using money from our joint account. So it wasn't just his mother's $10,000. They had money in it, too.
There was additional money from the joint account paid for the settlement costs
Right.
as well.
Right. Now, I heard a statement that there was an appraisal of $150,000 on this house. Absolutely not. If you look at the application for the 2010 loan, you will see that where it says value of the house, it's on his application. You will not find an appraisal of that. That was his statement of what I think my house is worth. No company signed off on that. So we don't have a value for that house at that time. And he took out more than he owed.
So talk about the appraisals, because
Yes.
I'm trying to understand why, if the May 2020 date was closer in time to the end of marriage date that the judge picked, why choose the July 2021?
And in normal circumstances, I would agree with you, but this is not normal circumstances.
Okay.
Dirk Snyder, the appraiser we brought in, testified that starting in about May of 2020, the housing market started to go up. And by the time of trial, it was still going up. And I think that the only reason it's not going up right now is because the interest rates have gone up. But so what happened was my client sitting there during all this time of all these issues in this case and saying, well, is this house worth more? It's no different than retirement. We routinely give people retirement. If you have a retirement account that you rolled over during marriage and you put nothing more into it, what do we do with that retirement account? We give you all the gains and losses. That's exactly what's happening here. And the judge specifically said, here as it is on page 5 of her decision, the current real estate market has had a 28% average increase in the sale price of existing homes on the market. That's from the Dirk Snyder. And therefore, a second appraiser valued the home at $230,000 in July of 21. Appraisals are based on market value, what someone is willing to pay for the property. In the second appraisal, the comparable homes were typical sales in the area. The difference, here it is, in the appraisal only has to do with the current market conditions. That's her reason for doing it.
So that would be, and
passive.
you're saying that's sufficient reasoning.
Absolutely. It's
Okay.
passive growth. It's passive growth. And the case law is that she can pick any date she wants as long as it's not an abuse of discretion. And she had-
And she explains her reasoning.
Yes, and the other appraiser didn't disagree with Mr. Snyder's claim that it was purely market conditions. I want to talk about child support real quick. Father got credit for paying the child care. He paid it voluntarily, number one. There was no order. 75N, keep in mind legally, the short court had every right to go back to the 75N date. That was specifically preserved in her June 18th entry of 2021, I think it was. Yeah, 2021. So she had every right to go back. What she did in the current child support, she didn't include daycare. She said you each pay your share, your percentage share. So if it wasn't included now, it's not retro. It didn't go back. He didn't get hit twice for child care. That's not in the worksheet. That's paid separately. He'd already paid that. It's done and over. As far as the amounts of income are concerned, he claimed he made $32,000, I think it was in his affidavit, and when we went to court, he didn't dispute that. She, as I told you, if you look at Exhibit R, shows you she made about $38,000 during that period that she was unemployed. And she exactly testified that I was looking for a job, taking the kids to daycare so I could find a job. She did find a job. And she testified that on cross. And she said, well, what about the documentation of your effort? I asked Kathy for that. Well, not in a formal discovery, and you'll find no motion to compel about that issue. You'll find a motion to compel before I even got on the case on another issue, but you'll find no motion to compel because there was no discovery request for it. It was an informal thing. And once she got a job, you'll see me ask her, once you got a job, did I ask you to give it to me? No, she got a job. So on the post-separation equity, okay. You don't lose your passive growth equity because you're out of the house and not paying for the mortgage. Again, it's passive growth. Neither party had anything to do with the growth and the value of the house. She stopped paying in April. She doesn't have to keep paying till July to get equity. That's a pay down of mortgage that increases equity. There's two ways to get equity. One is pay down the mortgage. The other is to have your house go up in value. It only went up because of market. The P&G stock, which she calls Equitini, that's the name of the company.
And what that comes down to is whether it's traceable.
Yeah, but here's the problem. He sold, contrary to his restraining order, during the divorce we found out at trial, he sold a bunch of shares. So I said, okay, trace for me which shares were marital and which shares weren't. I don't know. Some were, some weren't. Well, he couldn't trace what he sold. So there was 104 shares acquired during the marriage. If you look at the list on Exhibit 18, I'm not sure of the page number, first page of Exhibit 18, it shows the last of the voluntary contributions in 19. There was a whole page of those on page 3 from 2016 to 2019. Voluntary contribution. That was $100 per month they put in during the marriage. I said, okay, why are we down to so few shares when we looked at the current statement? And he said, well, I sold some. You sold them with the restraining order? Well, I knew I'd have to pay Jackie money, so I sold them and put them in a bank account. Okay, well, which ones did you sell? Marital, non-marital, or mixed? I don't know.
What was the amount that he sold?
I think it was about 200 shares. It came out to $38,000, he said.
Okay. Because wasn't there also, I thought during the marriage there was 93 that was sold.
He sold, right after they got married, he sold it to pay for the wedding, so that's gone.
Okay.
He doesn't get that back because he used it to spend, he spent it. But there's 104 during the marriage. That's the very least she should get half of. And since he can't trace which ones were marital and which ones were separate he sold, how do we know what's left? On the custody issue, the judge was very attentive to the witnesses, and she asked questions of her own. The bottom line that she came up with was we have to keep this child safe and feeling safe. And this child should be able to reveal anything she wants to reveal. But Dad had cut her down on that when he said in front of a supervisor who was not family, she said, I told the doctor something. And he said, I told you not to lie. Now, we're being told, go look at that section, because we're being told, oh, well, it was clear that she meant I told the doctor an untruth. No, she just said, I told the doctor something. And he immediately jumped to, I told you not to lie. So right there, we see that he's not accepting anything she has to say, and he has now put her in a position where I can't tell Daddy. Daddy won't keep me safe.
Well, one of the arguments here today had to do with whether it was necessary for there to be for the child to be brought into another home during naps, while there was already an adult in place for when the child went to the bathroom.
But see, what you don't know, and if you read the transcript you'll see, is his family lives real close. I think his one aunt might even live within a couple doors. And so what happens is they can come over when the kids go to the bathroom and then leave. But then if the kids are asleep, you want somebody there to make sure nothing happens. Because if you read the transcript and the Marison Center report, this happened when the child was sleeping. The dad came in and did something.
My understanding of the bottom line of the judge's decision, and I think everybody's on the right page today, is not necessarily that she believed that Dad did it, but the dad wasn't accepting the child or helping the child through this, and the child believed it happened, and the father wasn't doing what he needed to do to make the child feel safe and comfortable.
Correct.
So my understanding of the judge's decision was that, Dad, as soon as you get some therapy on this subject, come back to me, and I would be willing to change or consider changes here.
Correct,
Right?
correct, yes.
Okay.
I mean, this isn't set in stone, no child issues are. So yes, if he came in and showed he was really making an effort and brought his therapist in to say that, and it was the right type of therapist that Dr. Bassman recommended, then yeah, she would look at the issue, no question. I think I've touched everything. Is there an issue that the court would like me to expound on?
No, because you talked about the child support already, right?
Yes, so I think the father got the good end of this deal, because the judge didn't use the $38,000 my client was making during that interim period. She used her $62,000 new job. So he actually got a benefit of the higher income for her, reducing his child support. I mean, it came out to a couple $100 per child. So it's really minuscule. See if I have another point. I covered most of it. Oh, the delay in the house appraisal was blamed in the brief on vocational expert. That's a disingenuous argument. Dad had a food truck. Guess what happened to the food truck in the pandemic? We were told, well, Dad's going to get a job. And then Dad didn't decide he's going to go to nursing school. That's what he testified to at trial. I'm going to go to nursing school. Well, he has no history in nursing. He has a history in the food business. So, we might have had an opportunity to argue his Social Security statement and things like that, his food history, but no, now I'm going to nursing school. So we brought in the vocational expert to give the judge something to go on, and she didn't go on it. He said $49,000 a year, and she let him go with the $15.50 an hour he's making as a nursing student. So he got the good end of that deal.
Didn't the court also say that after he becomes a nurse and gets licensed, that she will reconsider that?
Yes, just as child support is always reviewable, just as child custody is always reviewable. So yes, she said that it should be reviewed. And he's there now, and we need to go back and have that reviewed when we get the relief from stay. Thank you, Your Honors.
Thank you.
Thank you.
Just to touch on a couple of things, in regards to the attorney's fees and the court's comments about there being experts and things involved in this case, wife paid a vocational expert and an appraiser. Husband's expenses actually were much higher than wife's in terms of paying the experts to come in here into court regarding the sexual abuse allegation. He had Valerie Allen.
There's no evidence of that.
Well, we're at the trial. We're not at the trial court here.
I know, but
Yeah, we've got the record.
So my client had Valerie Allen, the party's couples counselor, testify. Ashley Gold, which was mother's counselor, the guardian ad litem, had to testify. He hired an expert. His name's totally escaping me right now. I'm sorry.
Ultimately, we're looking at whether it's an abuse of discretion.
Yes.
So, what would you say was an abuse of discretion with regard to the allotment of the $15,000 of attorney's fees to wife?
Well, I think that in terms of the factors that the court considers with granting these attorney's fees, there aren't any factors that go into wife's favor. So from my perspective, the entire distribution of attorney's fees was an abuse of discretion. In terms of the house, father is not this passive growth, father's not benefiting in any way from the passive growth of the market. He's kept the house, he's still in the house. Wife was able to obtain housing at that time at the numbers, that they were in January of 2020 when she moved out of the house.
But is that what we look at, whether father benefits from the passive growth?
Well, I think that,
He could have sold the house.
well, when the court is determining whether or not to use a different date than they're using for the valuation of all of the other property, I think it is a consideration. Not necessarily whether whether husband is benefiting from the growth, but when you determine when these parties financially separated, essentially, I do think that's important.
So your argument is that the date of did the court use the last date of the marriage or the date of the separation for the assets?
For the assets, they actually used January of 2020, which was the date of separation.
Okay.
Yes. It was not technically, I would argue, when they financially separated. I would argue they financially separated in April 2020 when she stopped contributing to any of the household expenses.
Well, one of your arguments is that the court failed to explain its reasoning. Are you still arguing that? Because I believe, opposing counsel did read part of the order where the court, but it could be argued, explained its reasoning for choosing the July 2021.
Yeah, so
is that not enough?
I don't think it was enough. I think that the court did not explain why it was choosing a different date for that particular asset. There was no explanation of why it was important for this particular asset to be this date versus the other assets this other date. So I don't think that explanation was sufficient for explaining why we're choosing a different date.
So the explanation wasn't sufficient. There was an explanation, but it wasn't sufficient.
I'm not even sure I would really argue that there was an explanation, but if you're calling what the court wrote there an explanation, it was not sufficient. And then in regards to the parenting time, and you summed up correctly, essentially what the court sort of...
And counsel, you have 1 minute. Okay?
Thank you. In big picture terms, what the court was saying about the parenting time and the custody, I think my biggest argument about that really is that there was no evidence that the court accepted that my client's therapist wasn't working with him on these things, and that wasn't true. I spoke to the guardian ad litem. I went through each of Dr. Basman's points with the guardian ad litem and asked the guardian ad litem whether she talked to my client's therapist about whether she was working on these things with my client. And her testimony was that yes, my client's therapist was working with him on these things. Now, it was delayed because the information back and forth was delayed, but I don't understand where the court came to the conclusion that my client's current therapist was not working with him on these issues. So
would you, you're saying that that's an abuse of discretion, correct?
yes.
So are you saying that that's arbitrary or unreasonable or what?
Well, I think it's just against the evidence. The evidence showed that the GAL had spoken to my client's therapist about these things. She testified. I went through each of the factors that Dr. Basman laid out in his report, that my client's therapist needed to be working, that she needed to see from my client's therapist that they were working with him on. And the evidence was that my client's therapist is working with him on these things. So I just think it was against the evidence, essentially.
Thank you.
Thank you.
Thank you both for your arguments this morning. We will take the matter under submission and issue a timely decision.
Thank you.
And have a wonderful afternoon.
Again, the state's willing to submit on our briefs.
Okay, well, thank you, and thank you for waiting it out. Have a great afternoon and have a wonderful week. Okay, that ends court at this moment, and then we'll be doing Zoom for the final case.